Mr. Marnerakis,
Yes, Your Honor.
you may address the court,
Thank you very much.
and you have 10 minutes for your argument, and the clock in front of me will indicate to you when the yellow light begins to flash, you're coming to the end of your time.
Okay, Your Honor. This case was initiated by the opposing party regarding the collection of fees, and I am mentioning the subject of fees once again. There's an exhibit of the bill that triggered this lawsuit from the other side, and it can clearly be seen there. It's a very unprofessional bill, has no dates, no amounts per task. Generally speaking, it's only my opinion, but every attorney that look at the bill, they seem to think it's very unprofessional, and to use a common word, was fast and loose, a bogus bill. Now, the reason I mention it again is the fact because the opposing party is requesting once again legal fees, and in fact, they have submitted. I'm sorry, I want to apologize to you. I have to, if I lean. In fact, they have requested additional fees, which through a motion they submitted sometime after my brief. Those fees include a substantial amount of monies for legal work that was done outside this case. It has nothing to do or no connection whatsoever with this case. It was a case in the district court, U.S. district court, and the district court never awarded them any monies. So the inclusion of any time, legal time or legal charges for those particular tasks, I believe it's illegal and unethical because it has nothing to do with this case. So if the U.S. district court wanted to award them fees, they would have done so, and it would have been clear. Or if they wanted to get additional fees, they should have gone to the district court and request those fees. So here, once again, they are coming into this. In their brief, they request fees which under illegal and unethical pretenses. The case itself is a question in this case is whether this honorable court has jurisdiction or whether there was a need for this case to come to this court. And because under MGLC 211 Section 3, a submittal to this court must be extraordinary, and as the other side in the brief as well said, may not sought merely to substitute a normal appellate review. In this case, unfortunately, I did follow the normal avenues available to me, contrary to what the other side states in their brief, and there was no other avenue I could have sought but to come here. I did go to I was in district court. I went to the appellate division of district court where I was dismissed.
Mr. Marnerakis, did you, in the appellate division of the district court, I know you filed many motions, but did you file in that court, the appellate division of the district court, a motion to file your notice of appeal late?
Yes, I did, Your Honor. I filed, I did two filings. One was I filed my appeal. Unfortunately, I was outside the 10-day limit.
And then did you ask the appellate division if they could increase the amount of time? So
yes, I did, Your Honor. That was done on, I believe, August 11. The docket indicates that. And
okay.
August 12, I believe, it was when the decision was made on that. Now, what I would say there is the fact that unfortunately, the notice of the court was defective because it did not state in it the fact that I only had 10 days to file an appeal. That was problem number one. Then was problem number two. I went to court personally. Well, actually, I first called, then I went to court personally. There's an affidavit in my brief which states so. And I went personally, and I asked to file my, what I had to do to file my appeal for. There's a special form or whatever. And they sent me to the court of Fitchburg Court. They said, we don't do it here, you got to go to Fitchburg Court. So I went around and around, and by the time I was back, it was well past the 10 days, you know.
Okay.
And the dates that also the other side states a dismissal date as May 23rd. It indeed was May 23rd that the case was dismissed for the first time, but also on August 14th, the orders of the court were vacated, and new orders were installed, and during that time, so which means that the May 23rd date was replaced by the July 14th date. I'm sorry, I said August. It was July 14th, and so I did make two motions. One motion was for the appeal. The second was for the enlargement on time. Then subsequently to that, I also went to the Superior Court, which prior to that, and they sent me back to the Appellate Division of District Court. Subsequently to that, after an order was issued against my having any further pleadings in the court or the district court, and I believe that was a very unfair order because on one hand the court says that I was over litigating, and then on the other hand the plaintiffs say that I didn't follow and I didn't do what was right. I didn't follow the avenues I was supposed to follow. Another error in their brief also is the fact that they mention, as a matter of fact, they make a point in a footnote to suggest that I did not go to the Court of Appeals. Now, this is misleading and false, and intends to deceive the court in some way, or maybe is in error. And there's the documentation there that supports the fact that I also went to the Court of Appeals. Unfortunately, the district court refused to have any cooperation in assembling the record. In order, before I went to the Court of Appeals, I was supposed to request the assembly of the record. After the assembly of the record, of course, I would have had, I believe, 20 days to file an appeal to the Court of Appeals. The district court refused to cooperate and assemble the record, so I had no choice but to go without their approval to the Court of Appeals and request that my appeal is and I submitted my appeal there. I spoke to two clerks there. I spoke to the first clerk, who wasn't very sure, so he asked the second clerk, and they decided. I'm not certain why, but they decided, they were ones that said that the case does not belong in the Court of Appeals. Therefore, I should bring it to the Single Justice Division, and this is how the case went there, and from there went to the full court.
Thank you, Mr. Marnerakis. I think we understand your position. You've been very clear. Thank you.
Thank you, Your Honor, but I don't know, I would have liked to say a couple words regarding the extraordinary circumstances, because your honorable court has to have some kind of proof that the circumstances were extraordinary, and they indeed were. As a matter of fact, I did make a motion for continuance on about March 20th because my wife had a tumor in the eye several months before that, had radiation, then she had a total nucleation, a total removal of the eye. And I needed some time to take care of it. She couldn't see. I had to go and do whatever needed to be done for her. I had to take her to her appointments. I asked for 60 days. continuance, and the court would not give me that continuance. Subsequently to that, also, speaking about extraordinary circumstances, I broke my hands. I both broke my hands. As a matter of fact, if you can see, Your Honors, this finger is still, and this one as well, not this one not as much as this one here, so both my hands are broken. So on about, the trial was set.
Marnerakis, forgive me for interrupting you. I think you've explained the extraordinary circumstances, and the difficult part of arguing is the red light is now flashing, so your time is up.
Okay, thank you, Your Honor.
Thank you very much, Mr. Marnerakis. Ms. Godflex?
Good morning, Your Honors. May it please the Court, my name is Jessica Godfrey, and I'm representing the plaintiff appellee Phillips, Silver, Talman, Aframe, and Sinrich. There were two issues that I want to address with the Court. The first being that the single justice properly denied the appellant's appeal of the motion for reconsideration of the default judgment entered against him.
Ms. Godfrey, can I ask you a question?
Sure.
Mr. Marnerakis just informed the Court that he filed a motion to enlarge the time with the appellate division, but as I understand it, that motion was docketed in the district court and ruled upon in the district court, correct?
That's correct, Your
So
Honor.
the appellate division has never ruled on his motion to enlarge the time, correct?
I don't believe so.
Okay.
How do you file a motion with the appellate division?
To be honest, Your Honor, I'm not sure.
Well, if you're not sure and
don't
you're a
have-
member of the bar, how does somebody who's not a member of the bar know where to file it? Is it not the case that if you're seeking for an enlargement of time to file, you go to the court that is going to be hearing the appeal, correct?
Honestly, I'm not sure. I know that the notice of appeal is filed, would be filed in the district court.
Well, I assume you can go to either or both.
Where is the clerk's office for the appellate division? It doesn't exist, does it?
I don't believe it does. The district court,
They convene a panel of 3 judges when there are enough cases to hear the case. So who do you file with?
I would imagine that it would go to the clerk's office and they would take it from there, but
And that's the clerk that he filed with?
Yes, that's the court that he filed with, and it was heard by a district court judge. The court denied that motion. He does cite Perlin and Connors, the handbook of the district court handbook, excuse me, as his authority for denying that motion because it was filed too late. I do want to apologize to the court. There is an error in our brief regarding the date the default judgment did enter. I believe we cited as the first date that the third default entered, which was May 23rd. The actual default judgment that's at issue in this case entered on July 14th of 2003. But the procedural errors are still the same. It doesn't change the deadlines that were missed. The first being the notice of appeal, which would have had to have been filed by July 24th. The section cited by Judge Zide in Perlin O'Connor's cites to Rule 4 of the Appellate Division rules of the District Court, and that rule, or that section and that rule, states that any motion to extend the time to file a notice of appeal must be filed prior to 10 days after the expiration of that initial deadline, which would have been 20 days, or stated differently, 20 days after the date judgment entered.
So this was properly filed, in other words? The notice, the motion to extend the time was properly filed?
No, it was not. Judgment entered on July 14th. 20 days after that date is August 4th of 2003. The motion to extend the time to file the notice of appeal was filed on August 11th of 2003. So regardless of where it was filed or whether it was properly handled from that point, I think the court handled it properly because they didn't have authority to allow that motion. I think that the proper motion, I think there's a
Okay, so what was filed on August, the appeal was filed August 1st?
The notice of appeal, yes.
Notice of appeal was filed August 1st, so that was about 18 days after the judgment, as opposed to 10 days.
Yes,
right?
Your Honor.
And
What can I ask the question? Sorry, Justice.
No, go ahead.
Your client obviously knew that there was an attempt being made in the face of quite difficult rules as to which court, where, how you file it, that within a very prompt time after the judgment, Mr. Marnerakis was trying to appeal the judgment, correct? In other words, there was no prejudice to your client.
The reason that the
Was there
firm-
any prejudice?
Well, yes, Your Honor.
What's the prejudice?
There's been extensive litigation.
No, I
over a
understand that.
case
You've got a judgment, and in our system, you're entitled to an appeal. Now, sometimes, things sit around for a couple of years, and there's real prejudice because the documents have been lost and counsel have left. But this was done, within days, weeks afterwards, correct?
That's correct, but there's a history between the appellant and the appellee, and there's
No, I'm not
numerous
suggesting
frivolous
that
motions
I'm
that
not
are
suggesting that
filed.
it's improper to ask people to comply with the rules, but there's no prejudice other than wanting to use what you may appropriately use to bring the litigation to an end, correct?
We wanted the litigation to end.
Sure.
Is there case law that suggests that that the motion to extend the time for filing an appeal is a jurisdictional requirement? The 20 days in which to file is a jurisdictional requirement?
I know that Perlin and Connors does cite to a case, I believe I've cited to it in the brief, and that case says that the court lacks authority. It doesn't use the term jurisdiction. That's the only case that I'm familiar with off the top of my head, but it does say that the court lacks authority to extend the time if the first motion is filed later than 20 days after the entry of judgment. It does say that successive extensions may be granted for up to 180 days after the entry of judgment, but that first motion must be filed within that time period. Like I said, there's been extensive litigation in this case. Judge Zide, in one of his orders, indicates that there's been extreme tolerance to the defendant throughout the history of this case. The other issue that's on appeal today is whether the default judgment should be overturned, and I suggest that it should not, that it was properly entered, and there's no reason for reversal of the default judgment. There were 3 separate defaults entered against the defendant in this case. The first was for failure to answer interrogatories. The second was for failure to appear for trial. And the third was again for failure to appear at trial. In the third situation, prior to that trial date, Judge Zide had specifically ordered that there were going to be no further continuances in this case because there had been at least 5 granted on separate issues in this matter. 3 days before trial, the appellant filed a motion to continue the trial date. He claimed that there were problems with his hands and that he had sustained injuries. However, the records that he submitted in support of his motion to continue didn't support that claim that on the day of trial he was going to be unable to use his hands. There were 2 exhibits. The first was a letter from UMass Memorial stating that he was unable to use his hands for 2 weeks. That letter was dated April 15th, so 2 weeks out only brings us to April 29th. The trial date was May 2nd. The second exhibit was a medical record showing an order that the defendant must work a modified work schedule. And the period that was specified for that modified work order was April 2nd through April 10th. That also doesn't include the trial date. The defendant filed that motion 3 days before trial. However, it's clear from these 2 exhibits that he knew he had a hand injury prior to 3 days before trial. He could have filed the motion to continue earlier. Instead, it came in on the, a few days before trial. The judge hadn't ruled on that motion, and the defendant still failed to appear. On the day of trial, that motion was denied, and the third default judgment entered against him. Subsequent to that, there was a motion for reconsideration of that default judgment and the dismissal of his counterclaims. And the exhibits attached to that motion also don't support his claim that he was unable to appear at trial, prosecute his counterclaims, and defend the complaint against him. So for those reasons, we'd ask that you uphold the judgment and the decision of the single justice.
Thank you.
Thank you.
Take a break.